get started. Good morning, everyone. Thank you for joining us today. Topic that we have for today is when deals falling apart. We're going to go through factors that are affecting nowadays for deals. Deals falling apart, the issues that come up, and how you can avoid those issues, keep them in mind, to avoid them for your clients. Especially the market that we're seeing today. We're seeing a lot of issues, a lot of buyers not able to close, sellers closing desperately, not having enough funds, not enough equity to close out their mortgages. So all of that, we'll go through those issues and what to do in those issues and how you can avoid them. So that's Johnson. We will be sending you out PDF of these materials, so you'll have our contact information, so you can save and make notes as well. Me.
So your picture looks like you, and I look older in my picture. I don't know why.
I can Photoshop it for you.
That's our areas of practice. So if you don't know, we do real estate, corporate, commercial, wills and estates. Our offices, Mississauga, Toronto, Markham. For those of you who've worked with us, you know we do transactions entirely online. Clients don't have to attend in person. All transactions can be completed 100% online. We have very unique setup for signing appointments, intakes, which makes it much easier for clients. Social media handles, please feel free to connect with us on social media. We post regularly about real estate and also outside of real estate. Johnson's podcast. That's everything about real estate.
That's not Photoshop, by the way. Just to be clear. It really wasn't.
Right, so launch days today. I'll have Johnson introduce it.
So first of all, before we begin everything, just do a little bit of housekeeping. I don't know if you all realize this or not on how lucky you are, but I've been marveling at the technology. I've really come to appreciate, we do a lot of seminars and we get invited to different organizations. And I got to say, your company, your brokerage, between the microphone, the camera setup, the technology, I don't know if you guys realize this is very cutting edge. So kudos to TFN for what you put together here for your agents. That being said, we miss you all. I'm missing Jim's smiling face and having you all here with us. So when we do these monthly seminars, please feel free, come see us, come say hello. Certainly, if you have questions, you can reach us anytime. You don't have to wait till our meetings, but if it's something urgent that you think will be a good part of the discussion, so when we do the seminars, feel free to bring topics as well that we can do at Q&A afterwards. Number two, looking forward to seeing everybody at the party, the big party. We're very excited. This seems like a big extravaganza, and we're really, really excited for it. And number three, Diana reminded me, because if people didn't tell me, I wouldn't remember, but today is the launch date of my book. So turns out January 18th in stores worldwide. You go on Barnes & Noble, you go on Amazon, you order the book. It is getting shipped today. So I talked about that picture, Diana, right? And saying, in my picture, I keep looking younger. Why am I looking younger every time and compared to my picture? It's because I'm following the Bible 3.0. The 6 commandments of the chosen life. Nothing to do with Treza, nothing to do with why my deal is falling apart. This is a lifestyle handbook. I talk about my life experiences and what systems I did to bring me to have my best life possible. And I'm sharing it with the world now. So as far as eating, nutrition, exercise, those kind of life systems. But then from there, even as professionals, even if that's not important to you, you want to learn how to manifest, how to set goals, how to get ahead in life. It's all covered in there. So that's my baby, the Bible 3.0, and launch party is Saturday, January 27th. We'll post it online. So anybody wants to come and say hello and be there. I know Diana's going to be there and Yash is going to be there, and get ready for my big launch. So today is the day. So thank you for sharing it with me.
Congratulations.
So going from one high to one low, now that we're all high and excited about the book, now we're going to jump into help, my deal is falling apart.
So starting with what issues are affecting the market today, especially the interest rates that we're seeing today. Interest rates going high, uncertainty around interest rate, that's causing a lot of issues with transactions closing. We've seen buyers accepting an agreement determining the affordability on one date, and once the closing comes, interest rates have jumped up. They're not able to even afford that property anymore, which they thought they will be able to. So interest rates are the major factor. Inflation, people don't have, buyers are unable to come up with the funds, down payments, and other closing costs on the closing. They're finding it hard. We're seeing people using their lines of credit cards, which could come up with funds that are required on closing dates. And it is they are the real world problems nowadays. Interest rates, inflation, that's making it harder for buyers to close the transactions. The other factors are supply chain shortages, builders facing issues delivering the property on time, closings getting delayed from the builders, and we're seeing that as well. Wars happening, they're increasing prices, it adds up with inflation. All of that, employment uncertainty. We have seen transactions where buyers sign for an agreement, day comes, they don't have a job anymore, they were laid off, or the company was downsizing. The people are not left with a job, but they're not able to qualify for that mortgage, which they got a pre-approval for. So these are the problems that we're facing nowadays.
So Yash, you give always the politically correct answer. I give the less correct answer. But one thing I will say is this much. We even talk about the war in Ukraine, how when things happened over there, we feel it all over the world. And when other wars are happening and all sorts of uncertainty in the world. But this comes down to, and we all know this, it all comes down to perception. And when somebody opens up a newspaper online, when somebody is, reading the media, and what our clients, our ultimate consumers, people buying, selling, when they're reading doom and gloom and they're saying, "Oh, it's so bad right now," people saying, "Wow, okay, maybe I should hold up," and we all kind of feel that, unfortunately, where you could take any of these circumstances, you could spin it in a more positive realm or a negative, but unfortunately, negative tends to sell. So one thing we're all hoping, obviously, is the whispers are interest rates are coming down. Interest rates are coming down. This gets people into the buying mentality as we go into the spring. But unfortunately, as soon as the market seems to be getting stronger, and we're like, wow, we're really now in a good market. We saw this over the last couple of years. All of a sudden, the government introduces one thing or something happens in the world, and it kind of feels like everything's coming to a halt. So it gets very, very frustrating. One thing I will tell all of you is there's, I think, a bad perception. They're saying, oh, January is dead. Generally, there's no transactions. People are on vacation. People aren't really buying. So I'll just hold off my business. Yash and I can tell you, we wake up in the morning, there are still deals coming in. There are people that in a very colder market, and colder literally, things are happening. So your colleagues, the ones that are very aggressive and out there, they're not sitting by the phone, they're making things happen. So the good news is, I can tell you from a traditional January market, it's not that it's come to a halt. No matter what the media tells you, people are still buying new construction. People are buying resale condos, but it's certainly, you have to be more out there. But I was comparing it to, let's say, I think which market, I was comparing it to, when we had September 11th and when we had the US economy, 2007, 2008. At those times, it's like literally it came to a screeching halt. Like you did not have a single phone call. There were days where you didn't get a single email. That's scary. As lawyers, we have not reached that point yet, so that's a good sign. But certainly, we need to educate our clients saying, look, there are things out there, but you still need to upgrade. You still need a bigger home. You need to move. You need to be in a different area. So regardless of the circumstances, you always try to buy and sell in the market as best as you can. So know that those factors are there, but you can work around them.
I agree. Like what John was saying, everything in the news that interest rates going up, uncertainty, it affects the mindset of the buyer, and it not only even if the buyer the property is affordable, they can still proceed. They will still choose to see okay, I'll hold off. I'll buy at a future date, which is causing purchase prices to decrease and giving problems to sellers and buyers.
I'll give you a real life example. So I have a client, let's say, that needs to sell a home, okay? And they bought a home, need to sell a home, this kind of circumstance where they found their dream home, right? And so they're all excited. They got their dream home. Because of the market the way it is, they thought, okay, I got a pretty good price on it. Now we're going to sell our home. We're going to take a bit of a dip. Well, a bit of a dip, we don't have any offers for a month or two. And then all of a sudden we get an offer in, it's 100,000 below what we wanted or 150,000 below. So guess what? If I'm that buyer and I'm saying, wow, okay, so there's not a lot of action. I can go offer almost anything I want and maybe I'll scoop it up. That sounds like a pretty good market to buy in. Because how many times, like Dana, how many times have we seen in the winter time people saying, you know what, I see that there's deals to be had if I'm very aggressive out there, but I'll wait till spring, it'll be even better. And then as soon as it gets a little bit warm outside, everybody's flocking to open houses, everybody's starting, and then, oh boy, now it started again. So I have always found traditionally, you know, take aside COVID, this has always been traditionally the slower time. There's less inventory out there, but the smart people know you want to buy when nobody else is buying. So there are people out there that are smart to it. And I think that if I was looking to buy, I wouldn't wait the spring to summer. I think now is a very smart time to buy.
And we're already seeing changes in the market. Just in the last week, I heard from a couple of agents that they're facing multiple offers. Another day, a colleague of mine submitted an offer in Toronto on a townhome, 14 registered offers. So it's already starting.
But the thing is, and we know this, right? In the right areas, they're always going to sell. If I have a house on the Danforth, if I have a house on the beaches, it will sell all day long, regardless of the marketplace. It so happens I spent half an hour with a client, true story, last night, and we're going to get to it because help, my deal's falling apart. What am I doing? This is going to be a real life example. So as we go through it, I walked him through these exact scenarios. So we'll be able to talk in real terms how this actually works.
And Diana, it's Dan. We went from crickets to selling 5 houses this week already. So we are seeing people coming back.
Happy New Year, Dan.
Sorry, I'm late.
Talking about issues preventing of late closings these days, as I was mentioning, changes in circumstances of the buyer, they're losing their jobs as the closing date comes, interest rates jump up, they're not able to get qualified for the mortgage, which they have pre-approval for. All of these circumstances are changing. We recently had a sale, we were acting for the seller, and they had three mortgages on title. Interests started to accrue so much that they weren't left with any equity in the house. The transaction fell through because the sale price wasn't enough to cover the 3 mortgages. Transaction fell through. That's how interest rates are affecting the transactions nowadays.
Another real life story. So again, these real life stories really I find hit at home. When I was teaching with Aria, that's always the examples what the students asked for. So I got a call from a client yesterday. Again, bought a house, going to sell a house, got the offer on the house, accepted it. And during the conditional period, they had a 5-day conditional on financing. On day 2, they said, no, turns out we can't get financing. We want to release. We're moving forward. So the issue there is, and you all will encounter this at some point, one way or the other. Okay, why did they not exhaust until day 5? Did they really do everything possible? Now, if I'm the seller, do I really accept the fact that they didn't get financing? Am I going to hold them to this agreement? Am I going to say, you know what, I want proof that you attempted to get financing? So we kind of walked through these options with the seller. And I told them, look, at the end of the day, the unfortunate circumstance of it is, you know, they can more than likely off the record, they're probably going to be able to find proof that they didn't get financing. They go to any mortgage broker that they know and backdate that they attempted to get a mortgage and got rejected. The possibility is there, but I have seen court cases where the seller said, no, I don't believe you. Show me proof. The buyer refused to give proof. So then the seller says, you know, I'm holding you to this agreement and I'm not going to agree to the waiver. I'm not going to release you. Then you got to go to a litigation lawyer. You got to spend 5-10 grand to retain them and ultimately take them to court. But there have been cases where the judges have said, you know what, buyer? This is not a bill on a clause that you can just feel like on your whim, I can't get financing. If you cannot even show tangible proof that you applied for financing and got rejected, I'm not going to allow you to waive this condition. So just so we know that it's there, but in practical terms, do we want to tie up the property? Do we really want to wait? The seller's still going to have to ultimately relist the property, sell to somebody else, claim damages. And it's a crapshoot whether this buyer was on the level or not. I said to the seller, knowing your personality, you don't want to take this to the court. You don't know what their intentions are ultimately. Do they even have money to back this up? You know, when they put in this offer, if you go to sue them and you get a decision, will they even have money at the end of the day? Sometimes you just want to cut your losses, relist as soon as possible, find somebody else, move on. It depends on the person. So it's very important. If you ever encounter that kind of circumstance where you're saying, okay, this kind of issues come up now, and I don't know what to do. My buyer wants to walk away. My seller has a buyer that wants to walk away. My seller has changed their mind. Whatever the circumstances, you tell them in writing immediately. Speak to your lawyer, get your advice, do not act, and don't be the one giving that legal advice.
And most of the clients that we come across, they don't want to go to litigation. Once we go through with them what the effects are, what the process will be, what the timeline will be, what the finances, how much will you have to spend to go to litigation. Most of the clients would say, all right, I just want to get it closed some way or the other. Let's find a solution and let's close it. I think even with these problems there, we are seeing a lot of sellers, while they know how the market is. So the seller knows if the buyer is not able to close, if I go out, and somebody else won't pay me the price that I'm receiving from this buyer. So seeing a lot of clients wanting to close despite taking a hit. And I think that there's the situation that we'll go through, the how you can avoid such problems being discussed.
I will emphasize again, any kind of condition you have into your agreement, don't be on the side of the buyer and tell them you have this condition, so you're safe, you can walk away for any reason. It doesn't work like that. So if you have a status certificate condition and you have a home inspection condition, and you're saying, I'm not happy with the status, I'm not happy with the home inspection, we're not waiving. You do have to have, if ultimately the seller's going to hold you to it, you go to court, you are going to have to show a tangible reason. Now, it's enough to say perhaps, and this is going to be dependent a lot on what the judge is going to feel that day, but you have a reserve fund, for example, you're saying, I'm not really happy with this reserve fund. Well, I'm sorry, a $5-7 million reserve fund, probably not going to pass muster. $200,000 reserve fund when there should be $3 million, probably a better case, you know? So there is some discretion, but I've had scenarios where like it is the most perfect condo, perfectly managed, reserve fund's healthy, financials are good, budget is great. You don't really have a reason why you're not waiving this. That's going to be difficult. Same thing with a home inspection. So don't give your buyer a false impression just because you have a condition. Even it says it's in my pure discretion. Courts have shown, no, you have to come in with good faith and you can't just use it as a be all to get out of the deal. And very often that clause, that condition is simply coming back to, I have cold feet, so I just want it out. If you want to have that, then just put a condition in there saying, for any reason whatsoever, if I choose not to go ahead, but no seller in the right mind is going to accept it. So just keep these things in mind, please.
Also, we usually get questions from people like sellers, buyers having cold feet that, all right, the other people, if they're in breach, can we just terminate the agreement? Or if we think they're not able to close, can we just back out? A lot of people do have this perception that like we can easily walk out of the agreement. There's nothing much to it, but yes, there are consequences. We get it, especially in this market. We had a lot of sellers actually saying, "Oh, I sold it at less. I've seen now the purchase prices are coming back up again." Or buyers saying that I'm seeing the purchase price going down again. They're having cold feet and now, oh, can I just back out? I had a friend who just said like a lot of people back out every day. Why can't you just back out? But it's not very easy. That there are consequences and you can face lots of damages.
And we will get into that, so you'll know like the quantum. Like I'm not going to say it's unlimited, but certainly from one action of choosing not to proceed with a transaction, depending on how long it takes to resell the property and the carrying costs, etc., it can be very, very high. So just be forewarned that when you're going to sign a contract, you're going to go ahead with it. If you're not going to proceed, it's not so cut and dry that you can just simply get out and I'm just going to lose my deposit. It does not work like that.
One more factor that's happening a lot on pre-constructions, because I know you do a lot of pre-constructions. So buyers sign these agreements a couple of years, like 5 years, 6 years back. Now the closing date comes. The appraisals are not matching what they bought for. We've seen like appraisals coming $200,000-$300,000 less. That's a very major reason that we are seeing today for transactions not closing. There's still options to go around it. For example, we had a transaction where the appraisal came low. The person did not have enough money. What we negotiated with the builder was that whatever the difference is, they can register a mortgage on a property that this client owned, a separate property. So the builder agreed to it. The difference, they register on a different property, and we were able to close on a lesser purchase price. So there are options out there. We have to negotiate. Or again, it depends on what the vendors, what the seller says, what the builder says. But there are options. So if you have buyers for pre-construction and problems, you can send them over to us. We can see what their agreements say. can negotiate with the builder and see if we can work out something.
And I'm going to throw that in. That's a really good point because I've had assignments where it comes at a loss. So you purchase a property and now you sell it by assignment, but you're not making a profit on it. You're actually taking a loss. And let's say you're taking $100,000 loss, for example. You're like, I just need to get out of this thing and I'm not going to qualify for the mortgage as it is. So I'm not ready to take my loss and move on. That's fine. But when we do the agreement, we're going to make sure that that money is going to be there. So if I'm acting for the buyer of an assignment where you don't owe the original buyer, the assignor, the profit, they owe you the loss, we're going to get that money up front. So we're not left chasing them come closing time, because there's nothing worse coming closing time with the builder and you need that money to close the transaction. And the person says, oh, you know what, turns out I don't have it. Too bad, sue me. No, if you're going to sell at a loss, the way the assignor expected the profit, the reverse, the assignee is going to expect that loss back. So if you ever encounter an assignment where you're saying, okay, how is this going to work? Wait a minute, we're actually losing money on this. How are we going to recoup it? We'll help you with the clauses to put it together to make sure to protect your clients.
That's a great point. I think a lot of our agents have been in this exact situation. I never thought of it like that. So
Assignment where there are losses, it's like, because the thing is, like, there are agents involved, there are lawyers involved, and if one of those they don't have complete understanding of what the agreement is, like it will lead to a lot of confusion. A lot of, for example, we had a assigner lately. So assignee. They were buying and the assigner was selling at a loss. This agent was acting for both the assignee and the assigner. It was a loss. The agent had the assignee put a $50,000 deposit, but when I reviewed the agreement, I saw it's a loss. Like actually now out of the 50,000, the assignee has to get the money back, $10,000, because the deposit was higher than what they were supposed to pay. And I put in the clause. I asked them to get money from the assigner up front. It was $10,000. Assigner said, I have no money. I'm really in a bad condition. So I put in a clause where the lawyers were supposed to send the funds out of the trust account to our account. The lawyer missed that somehow, and now the money's lost. Like the assigner has gone away. They lost $10,000. And this agent was acting for both the assigner and the assignee. So most likely the assignee is going to go after the agent.
And assignments are filled with this kind of scenarios, especially if you have a foreign seller of an assignment deal. You have HST implications. You have you have implications as far as the gains on it, and so that's where you always need to vet. So in any transaction you have, know your client, but speak to the other agent if there's an agent on the other side and find out, do I have a foreign buyer? Do I have a foreign seller? What's going on? Can we even do this transaction? Because if we have a case where we ever have a foreign seller that they're not a Canadian resident for tax purposes, we need to know that, because especially on assignments, we can put clauses in there to help protect our clients so that they don't get hit with any funny bills. There's pre-wording in the standard form, but we can go above the standard wording and put holdbacks and more protections. So always get to know your people. And if the transaction smells funny at all, from either your client's point of view or from the other side, let us know immediately, because it's better to put in the agreement than have a firm deal and saying, okay, now what are we going to do? Oh, wow, we're going to be taking on tenants now, but there's no tenant clauses in the agreement. Once the agreement is signed, it's almost impossible to get those protection clauses in there, because they don't have to give it to you now. Now they're saying, hey, it's a firm deal. I didn't agree to it. I'm not going to do it. So early on, it's better to put those clauses in.
Thanks, Jonathan. We have a question from Jim.
Sure. Jim's first
Yes,
question.
Jonathan, you were involved in my seller's selling of the 19 all the way last summer. And I think that you recall there were 2 or 3 delays from the original closing date. Can you kind of elaborate on what happened with the additional deposit requested from the buyer and the purpose of that?
I don't have it on top of my mind, Jim. I do remember that we had a transaction where it was 2 or 3 extensions, but I don't have on top of my mind what happened.
So essentially, the buyer of my client's property sold their old property, and then the original buyer, the first buyer, delayed that they are closing. They are not able to close, or because of the mortgage situation. So it's a ripple effect through to my seller's closing.
Yes.
So I think you requested a $10,000 or $15,000 additional deposit. So can you elaborate on the purpose of that?
Oh, additional deposit on extensions. Whenever we are acting for sellers, we usually request additional deposits once we, as a condition for extension. And
I was gonna say, we have a slide on this specifically as far as options go in these kind of scenarios. So maybe Jim will hold off a little bit.
Sure,
When we have the slide, it'll make sense.
Yeah.
Okay.
great, thank you.
And sorry, guys, Jim, just so you know, from a builder point of view, when people have been asking for extensions on closing, we always ask for additional deposit in addition to a statement of adjustment, a charge for it. So that's a standard practice on the new home side, that the
Mhm.
builders ask for additional deposits.
Thanks, Dave.
When we go through the slide, we'll discuss about the adjustment for and the.
It's coming, yes.
It's not working.
I clicked for.
Yeah. Another factor that can affect is buying and selling the same day. I'm not sure if we've presented on this topic here, buying and selling on the same day and the risk associated with it.
I think some time ago, but we'll do a little bit of a refresher.
Yeah, we just do, if we haven't, we can always present that, but yes, buying and selling the same day, it has risks attached to it.
When people say, like, when we have a presentation that's just on what are the worst days to schedule my closing date? Worst date number one is the date when you're buying and selling on the same day. This is the biggest no-no. This is what you want to try to avoid. This creates the most amount of headaches, regardless of what day it is. And of course, people always like to pick the busiest day of the month, so they'll pick the 30th of the month or the 1st of the month. Plus, they're going to try to buy and sell on the same day. And please, why we do not do that?
Yes, and the thing is, like, if you, no matter how much you prepare yourself for it, no matter how good professionals you have on your side, no matter how long, how the gap between the closing dates, like you sign in the agreement now, your closing dates are 3 months ahead, so you're preparing a lot for it. Still, there are factors that can cause your transactions to not close on time. Like, for example, like it can be stupidest reasons. Like I always give the example when presenting on this. Like once we had a buying selling same day client, TD's wire system stopped working, and we we couldn't receive their mortgage funds. Like the sale couldn't close, the purchase couldn't close. It can be really messy. And for the client who has like moving trucks ready, sometimes they sell. They're in their moving truck, but they aren't able to close their purchase. Now they're out on the road. They need a place to spend the night. Jonathan has an example of where the seller slept at his home even after selling. Jonathan, what was the story?
Long story short of it, they were not able to close on the transaction on a Friday. The funds did not come through on time, and we ended up closing it on the Monday. But on the meantime, the buyer had already had their truck with all their stuff. The seller had their stuff almost all loaded up. And there was like a giant snowstorm as well to top it all off. Bottom line is, seller ended up staying in the property, and the buyer ended up crashing on the living room floor, and the seller let them. And I told them, do not do that. This is going to be very, I don't even allow my clients to, it's not up to me, but I tell them, no. And if you do this, it's against my advice. But don't even allow the buyer to bring in their belongings to store in the garage overnight or a weekend ahead or the week ahead. I tell them, if God forbid there's a fire, whose insurance is going to cover that? Not the buyer's, because it hasn't kicked in yet, because the deal hasn't closed. And I don't think the seller's insurance is going to like that very much. And having a stranger sleep in your house with you, not the best idea if you read the news these days. So do not do that, but it does come up, certainly. The one example which I always sticks in my head, which always worries me, is when you have a chain reaction. So you have a first-time buyer buying a property, the person selling it is buying and selling on the same day, to the same person who's buying and selling on the same day, to the same person. So there's a chain reaction of 4 transactions that all have to close on the same day. Turned out, and I was the last one. And from the first transaction, the buyers were first-time buyers, and they lost their mortgage the day of. Turns out, for whatever reason, they pulled the mortgage. We almost lost a chain reaction of 4 transactions. Somehow they had the parents. This is also several years ago. Today, that would never happen. They found out the morning of. By the afternoon, the parents co-signed for the mortgage, and they were still able to close on that day. Now, to get that mortgage, you'd have to get that mortgage reapproved. It would be several days for that. You'd have to extend all those transactions, or all those transactions will die. So another reason why we do not buy and sell on the same day. Diana had a question, sorry?
I had a question going back to the scenario where the buyer that has not yet closed has moved their stuff in, has maybe stayed. Is there any, somebody had told me this years ago, I think, when I had closed a home, don't ever do this because that buyer could become a tenant.
We're always worried about that, certainly. And that's another thing where we have an example, and that, it's based on the amount of days that they're gonna be in there. And also, we try to evidence this in writing. So the common scenario for us is, the sellers are elderly, the builder needs the property. So they're okay for them to stay in there for 30 days, 50 days, whatever it is. So they're leasing back to the people that property for $1. What we do is we make them sign what's called a license agreement, saying that you're signing this with your lawyer. You are not a tenant under the Residential Tenancies Act. It's purely for the purpose of the agreement. You understand that you have to vacate the property pursuant to this license, blah, blah, blah. But one thing we warn people is, let's say it's a 50-day license. And this person says, well, you know what? I'm not leaving because I have rights and I'm really a tenant, so I don't really care what you say. If you're going to call the police are going to say, oh, this is a civil matter. We're not going to get involved with it. So de facto, to get the person out, you're still going to run through the same process as trying to get the person, but you have to get the person labeled as a tenant, not tenant. And if you see what's going on right now with the tribunal, to get these orders, not so easy. So we're not a big fan of it. We don't want anybody staying on their property unless they are an actual tenant. Better thing to do is just extend the closing, and we'll close when the person's out. The same way I get this scenario all the time. People tell me, okay, I want to buy this property. I need this property, but what if the tenant doesn't leave? I'm okay with assuming the tenant, and then I got to take over to boot them out. I tell them, okay, fabulous. They stop paying rent that day, and it takes you 6 to 9 months, possibly more, to get them out. You're the one stuck with it. So yes, we could do a holdback if the seller agrees to it, and the money from the holdback will cover the rent if the person stops paying the rent. But folks, we live in Ontario. It wasn't called the Landlord Protection Act. It used to be called the Tenant Protection Act. So it's very pro-tenant. It is not easy to get somebody out of a property. We get asked this all the time. The person doesn't want to leave. What do I do? So bottom line is, if you want to make it really simple and you don't care from the closing date perspective, you're buying a property, keep extending the closing by all means until the landlord, the seller, is successfully able to get the person out. I think that's the best case scenario, but we do work through options. Bottom line is, we can do it, but it can be a little messy. So because tenants, you should be on radar for sure. If you're going to buy a property, we don't advocate to lease it, license it back to somebody. Just close, get vacant possession. The end.
So I just want to let you guys know. So the tenant we kicked out of I don't want to use the word kicked out, but the issue we had at Phoenix, it took 12 months to get the tenant out, because at the last minute the landlord did a secondary appeal, which was an illegal tenancy because the landlord officially never closed because they put the tenant in occupancy. One of my old school things, and I'm sorry if you've covered this, is whenever you are acting on the for a buyer, and there's a seller who has a tenant in the property, I always make sure that I put in the clause that they will not renew or put in a new tenant prior to closing.
I like that point a lot, Dan. And when somebody comes to me and they tell me, okay, this is going to be a simple deal. We're just buying a condo. We're not buying a multi-unit res. So I don't need all the fancy clauses. We'll just put in, we're assuming a tenant. I tell them, I'm really sorry to break it to you, but the clause that I use for tenant assumption on commercial from a multi-unit, because I call it commercial when it's multi-unit res, whether there's 6 tenants in there, 12 tenants in there, 1 tenant in there, I like all those protection measures in there. So if we're going to assume that tenant, saying that the landlord is not in default, they're going to get a tenant acknowledgement. All those kind of items need to be in there, because if you don't put in those clauses to protect your client, they assume a tenant. Turns out there's an issue between the landlord and tenant, and now you're the new landlord. Guess what? You could be at fault for all the previous landlord's misgivings. So anytime you see a tenant, be very careful on it, whether you're the buyer or seller, and let's craft the clauses appropriately to protect your clients. Bottom line.
And I want to throw one more thing, and I apologize if you covered it because I came in late, but, and this is a very personal thing, not a business thing. I had a house, one of my properties that I sold, and the buyer came to us like 15 days before closing and said, I need an extra a month to close on the property. And it wasn't, in the last couple of months, it was earlier on, but I had them sign a full and complete release of all the money held in TFN's trust account to me. So because that was also an important factor is that I wanted the release because I don't want to have to sue for the trust if he doesn't close and all this. So I said, I will allow the extension. There was a fee I tacked on for the extension, but also the complete release of all monies held in trust. So it was good for me because he had 100,000 in trust. It wasn't a small number, and he released it to me, so I didn't have to worry about it at a later date. Again, I don't know how you guys feel, the lawyers in this room feel about that clause, but it was very important because he ended up having to extend 3 more times after that.
So the thing is, from the court perspective now, I agree with you. I like the use of that. The problem is, depending on what stage you're using the clause, because what we used to do was when we were very cautious about a buyer, we would put the clause into the APS and saying that if the buyer doesn't close for whatever reason, then the deposit is automatically forfeited, released to the seller, blah, blah, blah. Turns out from the court perspective, we can't have the clause just as a clause in the APS. We have to attach a separate schedule for that clause, have the buyer seller separately sign that so that the buyer, then it can make it stick. If we have it just in the APS thrown in, even though it says they're going to forfeit it, they're not necessarily going to do that. We have to have a separately signed clause agreement just for that to make it stick, but we can make it out work.
Right, and so to your point, it wasn't in the APS, it was 30 days before the closing, so the lawyers drafted up the document to allow me to release the money and charge the fee as a separate document that me being the seller and the buyers had to sign. Exactly your point.
Well, yeah, and what I tell people is, this is, you got them by the you-know-what, so you know what, they need you to extend. You don't have to agree to the extension. Get whatever you need right now. Get the current deposit released to you, get an additional deposit, get it released to you, get it all in writing now, protect yourself, because once you come to the deal, if they're in default again, they may not agree to it. So if they're agreeing to an extension now and they're prepared to give you whatever you want, now's the time for us to ask for it, not on the second, third defaults.
Right. Thank you.
Thank you.
Over. Discussing buying and selling on the same day. If property cannot sell, they're not able to buy as well. Coming to title issues, another factor that can cause delay or closings going bad. Easements that are problematic if they come up, pending litigations just on title defects are like liens on title, spousal interests on title, old mortgages on title. We've seen old mortgages from 1990s. They were paid out but never discharged. Those can be problematic, especially private mortgages. We've come across mortgages, old mortgages on title, which were paid out, but now even the mortgagees are nowhere to find. We've come across mortgagees passed away. They don't have heirs or representatives. It's very hard. You have to go to court to get a discharge. And that's the reason at our firm, we do title searches the day we get the file or maybe a few days after. Most of the firms wait until the title search date to actually conduct searches. At our firm, we made a policy the day we get the file, within a few days, we'll do the title searches. No matter if we have to do title searches again near to the closing date, but we will do it just before, just so that we're clear if there's any item that needs to be addressed right away, or if it will take a long time, we have to go to court for it, so that we know it right at the offset.
So number one, this is why we don't do quick closings if we can avoid them. So people come to me all the time. Okay, I got this purchase, I got a sale. Can you close it in 2 weeks, 3 weeks? Yeah, we can, but without knowing specifics on the property. If this kind of thing comes up, we have a mortgage from 1950. We have somebody, a spousal interest, whatever it is, this kind of cloud on title, we want to have the time to deal with it. But this is also where, we talk about, and I talk about time, get to know your client. Well, get to know your property. So if you did not do your geo warehouse search, and if you didn't spot something and you said, come to us and say, Yash, Jonathan, you know what, I'll pay for it. Can you please send over to me, do the title search now. I have a client, he's gonna sell property, she's gonna sell property, but I got my suspicions there might be something funny with it. We have so many people that come to us before you even list the property, or they're about to list the property, but we investigate the property for the listing agent and they're like, oh, wow, I didn't realize that there's this and that on the title. Let's deal with it now, rather than, I'm sure it's fine, we'll deal with it when they do the requisitions. By the time we do the requisitions, if we're selling the property and the buyer's lawyer doesn't send us their requisition letter till 2 weeks before closing, and turns out there's some cloud on title, this could affect closing to the point that it won't close. I've had a couple of scenarios where I know the buyer got cold feet. The buyer was looking for every possible circumstance on how to get out of a deal. They were smart enough to still do their title search, realizing there's a title defect, knowing we can't deal with the road access, knowing we can't deal with a certain easement, saying, well, there's this easement, we didn't agree, it's a major easement. There's a road access issue, we're not closing. That's why we're not closing. So you can't give us good title. And in both cases, they were right. So if we had known that, we could have dealt with it to fix it, or we would have put it into the listing so that they, and then put an acknowledgement in Schedule B, so they understand that there's this cloud on title. If we had it in a Schedule B, when they wanted the property, they would have accepted the property subject to the title issue, and we're done. But now they have an out. So we want to avoid people getting out as much as possible. And I've had listing agents tell me, well, that sounds very scary. I don't want to intimidate the buyer. It's better to intimidate the buyer or have them miss it versus having a buyer that gets an out of a deal.
And it's like, after we started seeing this in our presentations, that like even sellers should start having their title searches before they list the property. We have agents contacting us for getting the client's titles searched before they list the property. So if there's any defect, they can take care of it earlier rather than waiting for the day on. We had a recent transaction. We were acting for the seller. So in all this transaction, what we have to do is the buyer's lawyer has to do a search against the seller's name to see if there's any judgment pending against that seller in that land registry. And if there is, it needs to be paid out. The buyer's lawyer, so now the seller's lawyer relies on the buyer's lawyer to do it. And closing date comes at 3 p.m. The buyer's lawyer comes to us and say, oh, we searched your seller's name and this writ's pending against this name. And we were like, it's 3 p.m. and like we have to close by 5, and you're telling us now. And we checked with the seller. It was in fact our client's judgment. We had to contact the creditor. We had to pay out. But if like at 3 p.m., it was a possibility that creditor never got back to us in time, which means transaction's not closed. So one way to avoid such thing on your sale transaction is contacting us, contacting a lawyer, getting title searches done. It will cost a couple $100 for your clients, but the amount of headache that can save in the future, that's worth it.
Also, please do not be lazy on putting the legal description of the property. So we've had too many of these where you're getting an offer in, you're acting for the seller, and it just says lot on plan, and that's it. But when you do the title search, there's this massive description together with subject to, and it puts all these measurements in there. If it doesn't fit on the first page of the agreement, say, see Schedule A, and Schedule A, make them write it out. This is a protection measure because if it's in there and it says subject to together with STTW, and is because you have a mutual driveway or whatever it is, if it's in the description, then they're deemed to have known that it's there, and it was up to the buyer to go and do their searches ahead of time, what that means. And I've had a lot of buyers come to us saying, we're about to put an offer in, but it looks like there's this easement, something, can you please check it for us? Same way, I always say for a seller, slap the survey, you have the survey, slap it into, make a Schedule C, D, whatever you want to call it, and then they're deemed to accept it. If the lawyer's not happy with the survey, we say, hey, it was in there. You could have reviewed it, you chose not to, you made a firm deal accepting the survey. So that's why I like to show ahead of time versus, seeing a very simple description, no survey, and all of a sudden we disclose it during the requisition period, and now saying, oh, this is new to us. So.
Oh, I agree. Like legal descriptions, because sometimes they can have entrusts on title, spousal interest, the judgments I was explaining to you. Like if they are on the agreement, we can still take a position that the buyers agreed to it, to accepting it the way it is if the problem persists. So that's a good strategy when acting for the seller to put out that whole legal description. breach of contract. So as we're talking about people backing out of the agreement, it's not very easy. Breaching your backing out of the agreement will be considered breach of contract. Default by buyer, as we were speaking, like buyers not able to close on the closing date. If you're not able to close on the closing date by 6 p.m., you are considered to be under breach. And the damages that usually if your clients ask you like what are the consequences of not closing on time, you can tell your buyer clients your deposit's gone. The seller has the right to forfeit your deposit. Any damages, the major damage being, let's say they sell off the property at a lesser price later on, that's the seller's damage. Carrying costs that the seller will have to for the mortgages, for utilities, all of that, they can come back to the buyer for it if they're not able to close.
The good news is there was a recent court decision. So a builder said, you didn't give us the money by 5 p.m. 5:01, you're in default and we're terminating the deal. And the buyer took them to court. And what the judge said was, builder's lawyer, you knew they had the monies. You knew that the bank was closed or there was a wiring issue, and they showed you proof that they had the money, and they were asking you that you're going to receive it by the next morning, but you not agreeing to that extension, knowing they could have closed otherwise, you're acting unreasonable. So I understand that the time frame is there, but you have to be reasonable in giving grace. So there's a big difference between the money's in our account and we can't get it to you for whatever reason. A lot of times, like it happens when we close an escrow, we can show proof we have the money. The lender sent us the money. We have the money in our trust account, but we can't give it to you in time for whatever reason. We may have even sent it to you, but it's not showing up in the other lawyer's trust account. We have the proof we sent it. You don't see it. So now we agree we're going to close an escrow. In order to close an escrow, ultimately, the other lawyer does have to see their money in the account. And the computer system closed at 5 p.m., so we can't register. The transaction's been done otherwise, we just literally can't close. So now that we can't close, we're going to register the next day, next business day, and de facto call it that it closed on the actual closing date. Title insurance covers the buyer, so it turns out there's some kind of title issue between the time it should have closed to the time it does close, we're covered. But that's a big difference between, oh, the bank said that the mortgage still isn't processed. We're going to need a couple more days at least. So there has to be a reasonableness in it. If you see the finite ending, it's going to literally close the next day. Yes. If we can't say for certain when it's going to close, then no. So be very cautious if you're acting for buyer or seller in negotiating these agreements as far as extension goes, because you can't be unreasonable in it. Now, specific performance is one that I get asked all the time. So it's not a two-way remedy. So seller cannot force the buyer to close. The seller cannot force the buyer to say you have to buy this property. If the buyer refuses to close, then the best seller can do is resell and sue for damages, which can take time until you actually resell the property to figure out your damages. From the buyer's end, they can sue for either monies, damages, or they could say, I want this property, seller, you better sell it to me. And what all the court decisions over and over are saying is they are leaning more towards, if the seller is completely unreasonable and there isn't a readily available supply of the exact same property, then what the court will say is, you know what, buyer, we're going to force the seller to sell to you. So that's one thing that, you have to consider on a case-by-case basis. So it's not something that is readily available, but it's more and more the courts are open to it. So you go to buy a house and there's 6 models of the exact same house on that street or close by, the exact same model, the exact same everything, then the courts can say, hey, you could have just said, okay, seller, you're not willing to sell to me. I'll go buy that exact same house next door and I'll sue you for damages because now I have to go pay a little more for this property, whatever be it. But as we know, in a lot of areas, you can't find that exact same property. I had one where it was a handicapped person and they needed a bungalow because they couldn't walk up and down stairs. And in that vicinity, there were no bungalows. And a lot of, new builds, it's hard to find a bungalow, especially in the GTA type area. And we told the seller, if you don't sell to us, it's taking them 3 years to find the right bungalow. We're going to get specific performance. Don't think the court's going to look very favorably on you why this person did not receive their house. And right away they came back and said, we're so sorry. We're going to close. So It's a threat of it. So we haven't been involved in exactly in closing a specific performance, but it's there certainly, but don't rely on it. So what we tell sellers are, you better have a good reason of why you're not agreeing to sell. And in this market, it's usually the case more the buyer has cold feet, but we have seen where sellers have cold feet as well. So it does go both ways.
And another concept is anticipatory breach. So that's a concept so both parties to the contract, they have a duty to mitigate their damages. Like if they know that the other party is going to breach, they can take a position that this is an anticipatory breach, that the other side is going to breach on the closing date, and I have to take steps to mitigate my damages. Usually, when let's for example, Dan was giving an example that 30 days before the buyer comes and says, I won't be able to close on closing date. We can consider as a seller that situation to be an anticipatory breach. We can say, all right, we consider that you're going to breach on the closing date. You've told us you won't be able to close, and now you're going to relist the property. If you don't want to do that, these are the extension terms that if you agree to, we might consider an extension. So that's a concept as well. As we're talking about mitigation of damages, both parties have duty to mitigate their damages. They have to take steps to mitigate the damages. It's not like you can act unreasonably in case the other party is breaching. You have to take steps to keep your damages to as low as possible.
And I'll just throw in right here, this is where a lot of agents make a lot of mistakes because your buyers come to you in 1 week after signing the agreement and firming up saying, I'm not closing. There's this misconception that we have to wait for a mutual release to go ahead and deal with the property. I can't relist the property. No. Your buyer has said they're not closing and it's not going to happen. You tell your seller, you better speak to your lawyer immediately because what we're going to do is we're going to send that threatening letter saying you've given us the indication you're not closing. You have 1 day to confirm that you are closing. If not, we're holding you in breach and you're not getting released out of this transaction. And we're going to relist the property, resell it, and sue you for damages, blah, 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 blah. So if you think you got to get a mutual release in order to relist the property, now you've agreed to a mutual release. How are you going to sue the buyer for the difference? So your client goes and relist the property, sells it for $200,000 or $300,000 less, took them an extra 5 months than what the closing date should have been. They've had all these extra carrying costs, but you have a mutual release. You release them out. So if you release them, how can you sue them now? So no, there's no mutual release. So be very, very cautious of releases. Don't insinuate a release. Don't go accept a release. Get them to talk to a lawyer first. Please don't just go. Because I've had so many people that come to me and said, oh, I signed the release because we had to release the property. Now how would we sue? Don't do anything until a lawyer is giving you the okay, please.
Just relisting and like selling to another buyer will be a mitigation of your damages. But if you're advising your clients that you have to mutually release and then you can enter into another agreement, then your seller or your buyer can go back to the previous parties.
I had scenarios where we told them, send a threatening letter saying that we're not releasing out this transaction, we're holding you in default, and then all of a sudden, and our clients can retain a litigation lawyer. We relist the property. All of a sudden, the buyer comes back on their hands and he said, oh, we found the money magically. We're going to be able to close. We have a choice now. We could tell them no, or okay, that's fine. So now on top of your $20,000 deposit, we want a $70,000 deposit and you're releasing the money immediately to us. And if you're in default, we can still sue you. So now we're holding these cards. Your client has the option to do it. And I've had these ones and we're actually still, and we do end up closing with them. We have way more security with it. Or we just tell them, get lost, we don't trust you and we're not going to sell to you. And we gave them the option of giving a giant deposit. They said, well, no, I'm not going to do that. And so, they're not serious. And why should I bother doing business with them? So again, there are options with it and it can end well as long as you plan it properly. But as we're going to get to, remember now, it's not the friendly, real estate closing your deal type lawyers. Now you're going to the unfriendly litigation lawyers, and they're going to say, oh, so you have a case where a buyer didn't close for you? Okay, $5,000, $10,000 retainer, then we'll start working for you. And people say, oh, where am I going to get this money? Well, you have to think litigation doesn't come for free, certainly. And because a lot of sellers say, I'm going to sue them, and I don't care how long it takes, I don't care how much it costs. But when you actually have to go into your bank account and pull out that money, not everybody's so brave anymore. And then they come back to us and saying, maybe we can figure out a way to close.
Strategies and options. So strategy is an option that, as we are talking about termination, relisting, that's part of the seller's mitigating damages. So if the buyer's in breach, the seller can terminate, say, all right, you don't have to, the seller who's not in breach doesn't have to agree to an extension. Extension is not a right of any of the parties. First, it depends on the circumstances, the facts. Both parties have to act reasonably, but that's a strategy. You can terminate the agreement with the party who's not in breach and relist the property. Extension, when we do negotiate extensions, so extensions, all of you must have heard, like if either of the parties not able to close on closing day, we negotiate extensions. And that now to answer Jim's question here, further non-refundable deposit. And when acting for the seller, why we ask for it is to see the buyer's commitment to close on the next closing day. We want to see the buyers not just asking for an extension because they can. We want to know their plans. Like, let's say a buyer comes to us, I don't have financing. I signed a commitment today. They told me the closing day is going to be 2 weeks from now. In that situation, what we can do is, all right, you know you're going to close in 2 weeks. You've paid 30,000 deposit. Let's put in more 30,000 because you were expecting to close today. You don't have your mortgage, but at least you have a down payment, right? So put in that, use that down payment to put in additional 30,000. Show us good faith that you're going to close in 2 weeks. Show us the mortgage commitment that you signed, that we know you're not lying, you're not just asking for an extension because you can. And that's why we ask for non-refundable deposit as a good faith, that they're acting in good faith, that they are committed to close on the next closing date. And usually we have them to sign releases. If they're not able to close on the closing date, the new closing date, the deposits are going to be released. So it's just a strategy to put more in line for the buyer, so that if they don't close on the new closing date, they have more to lose.
And if we're buying, selling on the same day, and all of a sudden the people we're selling to can close and they want an extension, we tell them, well, we have to try to negotiate an extension on our purchase. So we negotiate the extension on the purchase. Now our sellers want a whole bunch of extra costs. So we have those damages. So we got to come back to our buyer and say, now we're footing this bill. We want you to foot that bill. Plus we have the cost of our own property. So very, very messy. And this is why we have lawyer costs, because it actually takes more time to negotiate extension of 2 transactions than it is to close a transaction from beginning to end. Yeah.
And Jim, as you were saying, like on those extensions, that's the reason we were asking for more further deposits, so that the buyers, they have more to lose. And also, like another factor to it is, like if it doesn't close, it actually goes to litigation. As we were speaking, like winning a case is a separate story, but actually recovering the judgment amount is a different story. Like, what if you win in court, but now the losing party doesn't have any assets, don't have the money? What are you going to do in that case? Having that further deposit in trust makes sure that the money is there. Your damages are going to be covered from that money. Right? Second point, again, authorizing the direction of the buyer to release the deposit. Now, carrying costs, because as we're speaking, like sellers have their carrying costs as well if the buyer doesn't close. We ask for interest on seller's mortgage. We have per diem, like per day interest. Let's say they ask for 2 weeks, we'll ask the buyer to cover that interest. Nowadays, we're seeing sellers being in a bad financial situation. Sometimes they don't even have readily available cash to cover that interest for that time period. We've negotiated interest to be paid to our seller clients before we agree to an extension. Like we calculate the interest, we have buyers send it out to our trust account so that sellers have readily available cash to cover their interest from time period. Right. And we also, another factor, that interest on the balance due. So whatever balance was due on the closing date, we usually ask for interest on that. It can be any amount of interest. Of course, we can't be unreasonable with it. We have asked for like 7%, we've asked for 10%, 15%. We've asked for interest rates of that sort.
I've had one as well where it was a company, and the company name they were buying the property, and they asked for the extension. We asked for proof of who is the person behind the company, and we made them personally guarantee the deal as a buyer, so that when we gave the extension, if the deal doesn't close, we can go after the individual as well as the company. Because generally you see a company name, you have to assume there's nothing behind it. So all you're left doing is suing a company with no assets. If you go after them personally, they're more likely going to close. That's the reasoning.
reimbursing the seller for storage or rental costs, if they're incurring any, so any damages that result out of the buyer defaulting. Our attempt is to recover all of those damages.
My personal favorite is number 7 there. So buyer waiving any and all requisitions. So by agreeing to the extension, you know, and what Dan alluded to earlier as far as what builders do, builder will say, you know, you're waiving your timeline for compensation with Terrion. So by agreeing, you're not going to claim any Terrion costs against us if we require further extensions. We come back and say, you're not going to claim any title issues with us. You're not going to claim reason not to close. So you have that opportunity to take it.
The risk with the requisitions is that, let's say we are extending for another 2 weeks, and now 2 weeks come, the buyer comes 1 day before the closing. Let's see, we search the title again, and we see this title defect come up in these 2 weeks. And now even despite the extension, they have excuse not to close. They come across a title defect which they can use to not close. And in that case, our seller client, who was not on default on the original closing date, can now be on default on the new close date. That's a very important condition to be there, that they waive all the requisitions.
I had one where there was a title issue because there was an open permit on the property. Client says, oh, why didn't we know about this? You know, and I come back and say, listen, part of why we get title insurance says that you don't have to search for open permits. So unless we know it was a new construction or we know that it was substantially renovated, we don't openly search building and zoning because we don't incur the cost. But if it turns out there's an open permit, title insurance will say, we will insure over it. And what we'll do is you come to your new buyer buys the title insurance with us. And so they can close, and we undertake that we're going to close this permit as soon as possible after closing. So there's protection measures. And once title insurance says they're going to do that, the buyer has to accept it. This buyer came back and said, well, that's good, Danny and all, but I'm still not going to accept that. So no, I'm not closing. We extended this transaction until the end of time. And then once the permit's actually closed, sure enough, the buyer doesn't have money, isn't closing. It was all a facade. No idea why they kept this going. And now we're going to have to resell the property and sue that original buyer. So very, very frustrating with it. But that's one which otherwise, if they wouldn't have closed from the first place, we told our client, and the reason being for this open permit, but we gave them a solution with title insurance, the buyer had to have accepted that. That is in the agreement. And they chose not to. So just to know there's protection measures in there. But if you do have an inkling that this thing has been substantially renovated or it's kind of any uncertainty, we can search building and zoning. If the permit was never applied for, we can't tell you that from the search that we do, but we can certainly tell you if there's any open permits. And whenever I have an inkling and I've searched, I can tell you my success rate's about 70, 80%, where it turns out there's an open permit. And why I do that for my buyer clients, because ultimately, do you really want to close a property with an open permit if the chances are there is one there and have to deal with title insurance? No, you want to make the seller close it and give you clean title. So again, let us know ahead of time. The sooner we get search building and zoning, the better, so it can get dealt with.
The conditions again, another favorite is number 8. We need to get paid as well when you write extensions. And number 9 is all other terms for agreement of purchase and sale remain as is. Except as amended in the extension. So that's what our extension terms usually look like when we're negotiating extension on the seller's behalf. Yes, these are strategies that we use to get the best result for sellers, as best results as sellers for as possible. Termination extension we just talked about, purchase price reduction. So this is a strategy that we're using when acting for the buyers. As we're discussing, like on pre-construction, appraisals are not coming as significant as it was agreed upon. We use those appraisals to negotiate with the builder if they are able to reduce the purchase price. Of course, it's a very hard strategy to actually be successful in. We can try this, but it's not the success rate is not very good on this strategy.
I can tell you, I had one client that was selling like a $4 million property. The buyer almost came instantly and said they need a price reduction. They tried to get 120,000. They ended up settling at 40,000. And I told my client, I said, This is so BS. They're saying in the media that it's difficult to get mortgages. The second this released, now they're saying I can't get a mortgage. There was no issue last week. They're simply trying to get free money out of you. But they were elderly. They said, we don't need the money that badly. Just want to close. Don't want any headaches. Anyways, so we brought them down from like $120,000 to $40,000. But these people got a $40,000 gift at the end of the day. And even something along the lines of when we're talking about a vendor take back mortgage, I said to our clients, even if you get a second mortgage for $40,000, ultimately, if they go to sell the property at loss, there may not be $40,000 for you, but why not have something at least to hang your hat on? So there are other options, but certainly if you're a buyer and whether it's a builder seller or a reseller, and they're prepared to give you the price reduction, go for it. Sure, why not? But don't expect that. That's very rare.
Yes, I had a recent one where the appraisal came like $400,000 to $500,000 less. We were like negotiating, like it went on for almost a month, but the builder did not budge. The buyer was actually like eventually they were put in they were in breach. But yes, that's a very hard strategy. But yeah, I think it's more successful when it's a resale. Sellers who are maybe desperate to close, or they don't want to go out and relist again.
I recall one many years ago where we looked at the buyers, and turns out it was a parent and their child. And so the property was being purchased for the daughter. So we did a search on the mom. We found her property in the vicinity. So we have to know which area. So for example, the York region, Peel, Toronto, when you search under that name, if we know what area they're in, we'll see what their property is. We found their property ultimately. And when they couldn't close, we put a second mortgage against mom's property. Just for a protection measure, because nobody wants to give away free money. And chances are, if mom's got a $2 million house and she's sitting on a mortgage of $1 million, and we register a second mortgage at $100,000, chances are we're going to get paid, because if mom goes to sell the house or refinance, they can't do anything without dealing with our mortgage first. But on the other hand, if you're dealing with a property that is in the boonies, let's say, and they're not getting a lot of bites, yes, some people put in incentives saying, you know what, don't go to a bank, we'll give you a mortgage. We'll give you a vendor take back mortgage. That's a common strategy. But we warn people, do you really want to be a lender? Do you really want to deal with this? I had one where somebody gave a mortgage in a property in the middle of nowhere, literally. And I told them, if the market falls, how are you ever going to sell this property? They ended up having to take back the property. When they took back the property, there was running a business as well. So selling a business and the space. The people ran the business to shit, basically. Now the business is almost dead. And they destroyed the property. And so now you got to take this back. It's better to go off into the sunset. Even if you're taking a little bit of a price reduction, it's better to go off into the sunset than have to act as a lender and recoup your property and deal with it, if possible.
Coming to another strategy, bridge loan that can be used to close. It's more applicable when, let's say, you were selling to buy, and now your purchasers in your sale transaction are now defaulted. We usually ask clients, let's say, even if you're agreeing to an extension, then don't wait for the new closing day to close on your purchase. You can extend and then use a bridge loan to close on your purchase. That's a strategy that you can use. You can come up with funds using equity in your current properties to close on your purchases. Bridge loan is usually a short-term loan where the lenders usually give out funds on a promissory note. The lawyer acting on the sale and the purchase will undertake to pay back the institution, the bridge loan institution. It's mostly banks that you're getting your new mortgages from. Let's say if you're getting a mortgage from CIBC to close on your purchase, it will be CIBC who will agree to bridge. The other lenders won't want to get into this transaction. It's usually the same lender who will let you out. Let's say you have CIBC as your current lender on your sale, and now you're purchasing without a mortgage. CIBC will agree to bridge that. It's usually the same lenders you would want to go to.
There are institutions and people out there that specialize just in bridge loans, and they specialize in it because they're going to be very, very costly of what they're going to charge you for the setup fee and everything else. Plus, most of them, it's not like it used to be, when the dollar figures, when you're giving a bridge loan at $40,000, $50,000, and you give a promissory note. What is a promissory note saying? It's saying it's an IOU. So I promise to pay you back if the deal doesn't close. And then it's in there that the bank has an opportunity to go and register another mortgage against the property, protect themselves. But what happens in the meantime, if CRA put a lien against the property, or there's a tax lien against the property, or whatever being, so I wouldn't rely on promissory notes. What if they went to a different lawyer, sold the property, and nobody knew about this promissory note out there? So there's a risk. So a lot of lenders are saying, especially the ones specializing in it, yeah, we're not going to rely on IOUs. So we're going to register a mortgage. And we're not going to register it just against the new property. We're going to register it against the old property. We're going to do cross collateral. That costs money. So bridge loans with a setup, if we're registering mortgages, not so simple. So just as kind of a note, and you need to have 2 firm deals. So you're finally able to sell your property and you're saying, oh, cut it under the wire. So perfect. So I can get a bridge loan. You have to have firm deals. If the deal, one of the deals is still conditional, they won't give you a bridge loan on it.
Bridge loans can be tricky because sometimes some lenders would want to register on both the properties. If you have a first mortgage, as I was saying, there are lenders who lend even if they're not the same mortgagees on title. They could be lending out on the purchase, but on the sale, you have a different lender. And you would want your first lender on your sales consent before you register a second mortgage. So it can be tricky, of course. If you're advising your clients to bridge loan, you should ask them to speak with the mortgage broker, speak with us before they proceed with the bridge.
I had a couple of clients that Scotia sent them letters and saying, yeah, we found out you registered a second mortgage and you're not allowed to do that. So we're calling your mortgage. So they found out. How did they find out? Because on the property insurance, all lenders need to be named on the policy as additional insured to protect them. And when the policy got renewed and 2 lenders were on there and Scotia got the updated insurance and they saw the second lender, they said, yeah, that's not acceptable. So if clients are relying on second, third mortgages, there is risks.
Especially, I think nowadays, because like people who have fixed rate mortgages on low interest rates from before, I think lenders like these would want like any excuse to call back their loans nowadays, right?
And on top of it, to be frank, why are we all in this? Because we're running businesses, right? If you're going to act for a client who sells a property and you check the awareness and you call us, we pull the title search for you, and there's 3 mortgages on there, and you see the registered amounts, and that doesn't mean what's owing, but there's a risk. What if there's not enough money to close? What if they've over leveraged it based on the marketplace? So the 3 mortgages combined are $1 million, and they're going to be best getting 800,000-900,000. I don't know about you, but I want to get paid. I don't want to work for free. So do your math ahead of time with your clients. Ask them for recent statements. Work with them the numbers and see if there's sufficient money to close. If there's not sufficient money to close, don't know if I'm taking that transaction on. What's the point?
Seller take-back mortgage, as we're discussing, when the take-back mortgage is like, for those of you who are not aware of where the take-back mortgage is, like a buyer agreeing with the seller that seller is going to, let's say property's situation is $1 million. The buyer is going to pay $800,000 on closing date, and the remaining $200,000 will be registered as a mortgage in favor of the seller. The seller will be a registered mortgagee, and there will be regular payments or maybe a payment plan. It's everything in the agreement. It has to be like a mortgage commitment, any other regular mortgage commitment. It's just that the seller receives less on the closing date, and the remaining is registered as a mortgage. One thing that is, of course, the vendor will have to assess their risk. If there's enough equity, if they want to do their any other due diligence, let's say the credit checks for the buyer, post-dated checks. All of that is usually agreed upon in the commitment. Another important factor is when negotiating a vendor take-back mortgage. Let's say if a buyer is getting a first mortgage, they have to check with their first mortgagee if they will allow this. That's because now the vendor take-back mortgage will be a second mortgage registered on title. They have to speak with their institutional lender or even a private mortgage that will they allow second mortgage to be registered on the closing date. Because most of the commitments that buyers enter into, that commitment say secondary financing is not permitted on the closing date. And if subsequently you get a secondary financing, you have to get a consent. So if they don't do it, they're in breach of their first mortgage. So
what they sometimes do is off the record is they go to another law firm because the original law firm acted for the first mortgagee, so they cannot register the second mortgage, but the other law firm doesn't have that same obligation, so they will agree to do it. So sometimes people do that, whether it's to a vendor take back or it's to when they want to give their parents a mortgage, for example. Oh, you know, I gave my child X amount of money. We don't like being the same law firm acting for both sides. And then from there also we're not acting for both mortgages. So they'll have to go to a different law firm very often. So that's how people get around that. If you are acting, depending on who you're acting for, when there's going to be a vendor take back mortgage, if we're acting for the seller, you come to us because we're going to want to have mortgage clause in there, not just vendor take back mortgage, two-liner, that's it. No. We want all the terms in there for protection measure, making the buyer responsible for the cost, making sure the terms of the mortgage, and they're going to agree to any terms, and they're going to agree to a separate schedule to the registered mortgage. If we're acting from the buyer's end, we want it as short as possible. So we're not going to put the same clauses in there. So if you are doing a vendor take back mortgage, don't just slap two lines together and then give it to us to fix afterwards. At the very least, make it conditional on our lawyer review because we're going to make it more expensive. Or if we're acting with the buyer, we want less, certainly.
Coming to another point, revival of the agreement. So let's say one of the parties was in breach, your client was in breach. The other party, non-defaulting party, terminated the agreement. Let's say you were active for the buyer, the seller has terminated, relisted. You can still advise a client, like, if you want to try, still keep looking for money, still keep looking for financing if they were in default due to financing, or if they did not have enough cash, maybe ask around for friends, because like, even if you're noted in default, the agreement is terminated, it's been relisted. Like I was speaking with a lawyer once, they said that the buyer breached the agreement, the builder relisted the property. He told their buyer, still keep looking for financing, still keep looking for money if you can close. They went to the builder 6 to 7 months after. The unit was still unsold, and they agreed to revive the agreement. They redid the terms. That agreement can still be reinstated. There will be a revival agreement. There will be fees attached to it, but again, your buyer won't be in default. So that's another strategy. Good faith and clean hands. So that's a term that's used by the courts, that both parties have to act under good faith with clean hands, meaning that being a seller, being a buyer, you shouldn't be taking advantages of the clauses. You shouldn't be taking wrong advantages of the clauses in the agreement, as Johnson was mentioning. Like a financing condition, you can't just use it blindly. You have to have a ground to stand on, that this is why I'm using the financing condition to back up. Same like the courts are now leaning to that the time is of the essence, but it doesn't have to be. Like if there's technical difficulties and the seller is not actually facing significant loss due to such technical difficulties, they should agree to extend by, let's say, a day or by a few hours. So good faith and clean hand, it has to, in your communications, when we negotiate extensions, we make sure that our words or the conditions that we are putting in don't look like we're acting in bad faith. For example, if the buyer comes to us, asks for an extension for 1 day, and we're asking for $10,000 for 1 day extension, that can be considered bad faith in the court. So sometimes sellers do say, so they're in breach, we can charge anything we want. That's not the case. You still have to act in good faith. And how to avoid breach of contract? Draft better agreements, have a lawyer review, as Johnson said. We'll make sure you have the right clauses there, right wordings. A seller buyer put in questions regarding the property. So as we were mentioning, getting the title searches done beforehand, knowing the property very well, so that if there's any additional searches to be done, or complete disclosure between buyer and the seller, like any factors that the seller is obligated to disclose and disclose to the buyer, all of that stuff.
So it says know your client, know the other side, ask the other side the questions, find out what the situation is, because very often, if we would have had the information ahead of time, we could have drafted a better agreement based on the fact that we know how this buyer or seller is. So know the whole situations as much as you can. They may not tell you the truth, but at least you ask the questions.
Providing all deliverables, reports, surveys, leases, like anything under the agreement that buyer or the seller have to provide. It's better to provide it early in the transaction rather than waiting till the closing date. Because if there's any issues, they can be brought up earlier and they can be addressed.
I had a couple of assignment deals fell apart because the listing agent didn't bother getting all the paperwork from their client, the assignor. And when the deal went firm, all of a sudden, turns out there's amendments. There's all of a sudden upgrades and all this. Either they're going to get out of the deal or somebody's getting screwed out of money. So you make it very clear. I want all the paperwork. I want every single thing attached to this agreement, including the amendments, upgrades, etc. Because we got to disclose everything. You can't It's like when we get a status certificate. No, a status certificate that's missing all attachments is not a status certificate, or it has half the attachments. Get all the attachments, open it up yourself, make sure it's the right unit, make sure it's dated correctly, make sure we have everything. Because until we have a full agreement, we have not been given everything. So no, they haven't delivered.
Another, how buyers can avoid breach of contract is eliminating mortgage issues. The day like buyers contact us and we see that it's financing conditions, I always tell them go to a mortgage broker. You should speak with your mortgage broker right now to know your affordability. And I think you should be doing the same. Like if they have a buyer, they should be in contact with a mortgage broker and advise the right way. If they're buying and selling, of course, they can look into bridge loan as we discussed. Support from realtors and lawyers, of course, buyers, sellers both need realtors, lawyers to take a look at their agreements, to be on their side, to put in the conditions, speak about them, about issues that can come up on surveys, what title insurance is, what it covers, how to be ready for title insurance, status certificates, why it should be reviewed. Usually, whenever we get a buyer or a seller contact us, we usually like to do a phone call with them, go through the process, tell them what they should be ready for, ask the right questions. If they're a non-resident, how much do they expect to pay in down payment, things of that sort.
Love it.
You.
That's again on the book. This is really good. There's a lot of information here. And another reminder that we have so much to do as agents, so many things to double check, to think